Hello, everyone. Welcome to another episode of the Lifetime Legacy Lawyer podcast. My name is Thomas Vick, and I'm here with my co-host, Seth Wilson. Seth, how are you today?
Thomas, I'm doing great. We've got some sunshine out here, which is nice in the middle of February in Indiana to keep the winter doldrums away, which is a welcome sight. Enjoyed that and a nice clear sky this morning.
Absolutely. Great day to get out there and maybe go for a brisk walk or something like that. It's definitely a nice day outside. Well, we had another blog digest go out this morning. Had some various topics on there today. But one of them was about asset protection trusts. And there are a lot of different ways that you can go about an asset protection trust, different purposes for asset protection trusts, and they really vary quite drastically. And we thought we might talk about, a Medicaid asset protection trust today, and maybe some other asset protection trusts that kind of go along with the blog post today on the website. So, Seth, I'll hand it over to you. What do you want to talk about first?
Yeah, so asset protection trusts, there's sort of we need to do our normal estate planning and determine what assets are going to go where and to who. And that is sort of the first level analysis. And then we have the second level, which is, okay, how do we protect that? So maybe we need to put some terminology in the trust that restricts access to funds. Maybe it's an age-based limitation in some of those. So we have some of that blending, if you will, in our underlying estate planning. And asset protection trusts kind of take that next step of, boy, we really want this stuff to be locked down. And the big piece of the asset protection trusts that is different from kind of your normal estate plan trust or a revocable trust is I don't have control necessarily over that asset anymore. I can't change that trust anymore. And I'm sort of putting these assets over here for that defined purpose in the asset protection trust. I think probably the easiest way to understand that concept is in the concept of the Medicaid asset protection trust. So maybe walk us through what that looks like and how that works.
Yeah, so a Medicaid asset protection trust is a kind of trust that I draft for clients, and the purpose of it is to protect assets in view of the great expense that long-term care can have on an individual's estate. Excuse me. So the idea is to protect assets by putting them in the trust, and then there's enough separation between you and the asset that the asset is protected for Medicaid purposes. It's no longer considered a countable resource for Medicaid purposes. And it invokes the 5-year look-back period. When Medicaid is applied for, Medicaid will look at what do you own now and what have you gotten rid of in the last 5 years. And if you've gotten rid of something in the last 5 years for less than fair market value, then Medicaid will assess a penalty period. And that penalty period will be based upon how valuable the asset was. Generally, if it's $100,000 of value, it'll be about 12 or 13 months for an individual to have to pay for his or her own care in a nursing home or at home receiving health services. And so the idea with the Medicaid Asset Protection Trust is to start that look-back period while you're healthy and make it past the 5-year look-back period so that anything that happens after 5 years is going to be, the assets in the trust are going to be protected. And that's an effective way of doing it. You can keep perhaps your principal residence in the Asset Protection Trust, and that can start the 5-year look-back period, and it really doesn't change your way of life much at all. It changes who is titled on the deed, and typically an adult child will serve as the trustee of the Medicaid Asset Protection Trust. Generally speaking, parents have good relationships with their kids, and that's a fine way of doing it. But so that's a great way of protecting assets in view of long-term care. And generally speaking, when you've done that and you've gotten maybe 3 or 4 years into that look back period, and then long-term care is needed, you're actually able to protect everything in there because you got assets outside of the trust that are able to help, get you over the finish line, when you reach 5 years, and then Medicaid can actually take over. So that's a great way of planning it. And, we've worked together on trusts like that before and have been able to help out clients. And I think it's a great tool to use to help out estate planning clients.
Yeah, and there are other types of asset protection trusts available for kind of that specific purpose. Maybe there's some creditor issues down the road that you're wanting to address, or maybe it's a lawsuit potential or something along those lines. And so you can't do what's called a fraudulent transfer, right, into an asset protection trust. You have to be sort of forethinking in terms of your planning. And typically these types of trusts are, we're looking over a longer term horizon, and we can't do something on an emergency, quote unquote, basis to set this up and accomplish the outcome you're wanting to accomplish, because you're changing the nature of the relationship between you potentially and the ownership of that asset, and it needs to be transferred, and there's a lot of steps to get to that point, plus there's a lot of rules that apply depending on what you're trying to do. So very fact dependent determination as to what's available, how can you utilize and go through. But just things like the Medicaid situation, there are domestic asset protection trusts where maybe a second marriage scenario where you're concerned about protecting the assets from the first marriage and how that asset base is going to be handled in the event of a subsequent issue in that family dynamic. You've got the creditor protection and those types of things we talked about in terms of some of those things. We've got legacy trusts here in Indiana. We've got, there's just a whole flurry of things that could happen. And so really sitting down with a experienced estate planning lawyer to walk through what those options are and see if that's a good fit for your situation is helpful. So definitely more of an advanced planning technique in a lot of ways, but one benefit we really see, I think, in our practice on a day-to-day basis is that Medicaid scenario. And especially if you're able to protect the value of your primary residence because of this asset protection trust, that can be a really helpful tool in your estate plan.
It really can be. And like I said, when you're putting a principal residence into a Medicaid asset protection trust, it doesn't change your way of life much, if at all, because you're going to have, like I said, an adult child usually serving as the trustee. But then also you retain some rights with respect to the trust. For instance, you can retain a limited power of appointment, and that means that you can change who the beneficiary of the trust is upon your death. So you got control over that. I designed the Medicaid Asset Protection Trust in a way that will retain an individual's right to occupy the principal residence, so that homestead deductions are still able to be obtained for the individuals, for the clients. So again, a lot of ways of doing that, and you can retain an income interest too. So for instance, you want to protect a farm, but you need the farm to still give you the income that you need each year. Twice a year you get paid for rent, right? Crop proceeds and all of that kind of things that are shared. You can retain an income interest in the Medicaid Asset Protection Trust. That way you're able to protect the principal in the trust while also using the income in the trust as you have been in the past. So that's another way that the Asset Protection Trust can really help out for Medicaid purposes. You mentioned the legacy trust. Sometimes that, is a useful way of planning for a second marriage, just to separate assets, so that, one spouse has their trust, the other spouse has another trust perhaps, and Disclosure is really important. You hit on the idea that you don't want to do this in an emergency situation. I think that runs through any possible asset protection trust. With the Medicaid situation, usually a Medicaid asset protection trust isn't going to fit very well if you're needing Medicaid right now. An elder law attorney is going to have to figure out a different way of doing it for you, of getting you Medicaid eligible and protecting assets. But even with a legacy trust, you have to sign an affidavit. The client has to sign an affidavit that says, we're not fraudulently transferring any of these assets. We've disclosed everything, and everything is open and above board, essentially. I think some clients want to, just put some, items into a trust and that's going to solve all of their creditor problems. But actually, your problems are going to get worse if you don't openly disclose everything to your creditors or, to the Medicaid or whatever the case might be. So definitely it is an advanced topic. And if an individual is interested in this type of planning, you definitely need to go with an experienced attorney to help you out with it.
Yeah. And keep in mind that just because the tool is available, it may not be the best tool for the job. And there may be other options that accomplish the same outcome for you effectively. And so it's really one of those cost benefit analysis. And I like the advanced planning in both kind of the complexity thing, but also the get ahead of it thing. You want to have some advanced thought on some of these things, have that basic foundation built, and then these are sort of add-ons to the plan that can accomplish a specific purpose as you're thinking those through, whether that's tax planning and those kind of things from the federal estate tax issues, and all of that falls under this umbrella. So it's a lot of fun for the estate planning lawyer because they're very there's a lot of puzzle pieces to put together and make sure everything's done the way it can be. But the complexity that's there too can sometimes be a challenge for a client who says, well, I'm not quite following what we're doing here. And so working with that, find someone who can help you explain the process, what you're doing, what the outcome you're trying to achieve is really important.
Another thought that I had is when we're talking about asset protection trusts, maybe you don't have to do anything drastic during your lifetime. Maybe it's not a concern that you're going to have problems with creditors or anything like that, but you're concerned about your children or your beneficiaries and you want to protect them. Well, you could design a revocable trust that sets up trust for your children. Each child has their own trust, and there's no withdrawal right of principal or income. It's just the trustee's discretion in order to make a distribution of income or principal for that beneficiary's entire lifetime. So that might be a possibility that, you put some restrictions on how the trust assets are to be distributed to the beneficiaries over the course of time. And that effectively is an asset protection trust for the beneficiary, but you don't have to do anything drastic during your own lifetime.
Yep. Yeah. And we'll see that a lot in our practice where it's, look, we have an estate that we're trying to protect the assets for, and we're also trying to help support and accomplish the growth of our children to be productive members of society. And we don't want to just hand them the keys to the kingdom, so to speak, so they don't have no incentive to do positive work and those kind of things. So balancing those two concerns a lot of times is where these terms can kind of come into play in your underlying foundational estate plan, effectively locking those funds until those conditions are met later on. Absolutely.
Well, anything else on asset protection trust, Seth?
We could talk about this for hours, but it's one of those that really, as you give a high level overview of what that is in your article. I thought did a really nice job of summarizing that. The specific scenario that you're concerned with is really what would be there. So, as folks have questions, maybe reach out to you or me to talk those through, or to your local experienced estate planning lawyer to address these concerns.
Yeah. Well, good stuff. I enjoyed that discussion today. I think we'll probably wrap up the podcast now. Seth, how can people get in touch with you?
We are located here in the heart of Hamilton County, in the county seat of Noblesville, Indiana, and noblesvilleattorney.com is our web address, and it's the best place to get our contact information. How about you?
Best way to get in touch with me is go to vicklaw.org, and you can book an appointment through the website. So go to vicklaw.org. I appreciate it. As always, Seth, enjoyed it, and we'll talk to you later.
Sounds good, Thomas. See you later.